I inherited my father's property on a Saturday in October. I drove up to see it for the first time in 19 years. I'm a land use attorney. 30 years. I know how to read a deed. When I stood on the back porch and looked east across the lake, I counted 26 cabins on the far bank, docks in my water, an access road running the length of the shore. I went home. I opened the probate file. I turned to page 6. Exclusive right to authorize or deny any residential use or infrastructure installation within 50 feet of the ordinary high water mark. Runs with the land in perpetuity. Nobody had authorized a thing. I called my attorney. I told him, find out when their refinancing closes. 11 months later, I walked into a title company conference room. I placed the deed on the table. I turned to page 6, and I let it say what it had been saying since 1938, kicking things off from the start. Before we go further, share where you're watching from, and be sure to like and subscribe. Leonard Voss had bought the lake in the fall of 1938, a Thursday in October. The leaves off the hardwoods on Harlan Ridge, the county register's office, in a 2-room brick building on the courthouse square that still stood, the building repurposed into a surveyor's office sometime in the 1970s. He had paid $1,400 for 140 acres and a lake, the price reflecting the Depression-era land market in western North Carolina, where property moved at whatever a buyer could put together in cash, and the sellers were often families who had held the land for generations and could no longer hold it. The seller had been the Alderman family, 5 siblings, the last surviving members of a landholding that had once covered most of the ridge's eastern slope, reduced by the 1930s to the lake parcel and a timber lot that went to a paper company the same year. The Aldermans had wanted the sale closed before winter. Leonard had driven from Asheville in the truck he used for his grading business, had met the Alderman attorney at the register's office, and had signed his name at the bottom of 8 pages. Page 6 was where the water rights reservation clause appeared, the language inserted by the Alderman attorney at the family's insistence, the Aldermans having sold timber rights from adjacent parcels in prior years, and having learned from those transactions that the specific conveyance of water rights required explicit language if it was to survive future divisions and transfers. The grantor hereby conveys all surface rights, riparian rights, water column rights, and bed rights to Voss Lake, together with the exclusive right to authorize or deny any commercial use, residential use, or infrastructure installation on or in the lake's water column, bed, or shoreline within 50 feet of the ordinary high water mark. Said rights to run with the land in perpetuity and to be binding on all successors and assigns. Leonard had read the deed before he signed it. He was a careful man, a grading contractor who had spent 20 years reading survey descriptions and grade specifications, and had developed the habit of reading documents completely before putting his name to them. He had read page 6 and had understood what it said. The lake was his, and the 50-foot corridor around its shoreline was his in the specific sense that no one could build on it, use it commercially, or install infrastructure on it without his authorization. He had filed the deed at the register's office that Thursday afternoon, paid the recording fee, and driven home to Asheville. The deed had been assigned Book 14, page 212 in the Harlan Ridge County Register's records, a location in the deed index that would remain unchanged and unremarked for 84 years. Nora had been born in 1961, 23 years after the deed was recorded, the lake already established in the family's life as the place where summer happened. Leonard had built a farmhouse on the lake's western bank in 1947, a simple structure, 2 bedrooms and a kitchen, and a porch that looked east across the water to the ridge. He had added a dock in 1952, and a storage shed for the fishing equipment in 1958. By the time Nora was old enough to form memories that held, the lake property was the fixed point of the family's calendar. School ended in June, and the family drove up the mountain and stayed until August, Leonard fishing in the early mornings, while Nora's mother ran the farmhouse kitchen, and Nora and her brother spent the days on the water. She had learned to swim in the lake at age 6, the western bank shallows, her father's hand under her back, the mountain water cold even in July. She had learned to row the aluminum fishing boat at age 8. She had learned the lake's depth variations, the shoal on the southern end where the bottom came up unexpectedly, the deep channel on the eastern bank, where the big bass held in summer heat. The eastern bank had been open shoreline in those years, mixed hardwood running to the water's edge, the tree roots exposed where the bank had eroded. No structures, no docks, no access road. Leonard had owned the water rights to a 50-foot corridor on that bank, the same as the western bank, the same as all the way around. But the eastern bank's particular quality in those years was its undisturbed character. The trees, the roots, the bass holding in the deep channel below. She had stopped going to the lake in her early 40s, the demands of a land use practice in Asheville, then her husband David's illness, then the particular exhaustion that followed his death in 2014 that had made the lake feel, for reasons she did not fully examine, like a place she would return to when she was ready, and not before. Leonard had continued going every summer, older and slower each year, until the summer of 2019, when he had gone for 2 weeks in July, and had come back to Asheville and had not gone again. He had died in March of 2021, 89 years old, the grading business long sold, the Asheville house quiet around him in his last years. He had left everything to Nora and her brother Mitchell in equal shares, the estate divided with the particular Voss family practicality that Leonard had applied to everything. The Asheville house to Mitchell, the lake property to Nora. He had not explained the division in the will's language beyond the standard bequest formulation. Nora had understood it without explanation. Leonard had known she was the one who would read the deed. The probate had taken 7 months. The Buncombe County estate proceedings, the appraisals, the transfer instruments. The lake property had been appraised at $890,000, the valuation based on the 140 acres and the farmhouse without specific assessment of the water rights. The appraiser noting the property's lakefront character, but not reviewing the 1938 deed's specific conveyance language. Nora had signed the transfer instruments in October 2021 and had become the owner of record for parcel HR-001-0044, Harlan Ridge County, the 140 acres, the farmhouse, the western bank, and everything the 1938 deed had conveyed to Leonard Voss 83 years earlier. She had driven to the lake for the first time in 19 years, on a Saturday in November 2021, a 3-hour drive from Asheville, the last 40 minutes on the mountain road that climbed the western face of Harlan Ridge before dropping to the lake on the ridge's eastern side. She had made the drive dozens of times as a child, the road unchanged in its essential character. 2 lanes, the switchbacks on the upper section, the pull-off at the ridge crest where you could see the lake for the first time before the road descended. She had stopped at the pull-off as she always had. The lake had been there, 1,400 acres of mountain water in the November light, the hardwoods on the surrounding ridges bare, the surface flat and gray in the overcast. The farmhouse was visible on the western bank, smaller than she remembered, the dock extending into the water. The lake's general character was unchanged, the southern shoal, the deep channel visible as a darker band along the eastern bank, the ridgelines on 3 sides. The eastern bank was not unchanged. She had looked at it for a long time from the pull-off, the ridge crest giving her the elevation to see the eastern bank clearly, the trees that she remembered as unbroken hardwood from water's edge to ridge, interrupted now by structures. She had counted them from the pull-off, difficult at this distance, the November light flat, but she had counted what appeared to be 20 or more cabins on the eastern bank, the structures set close to the water, docks extending from each one into the lake, an access road running along the bank connecting them. She had stood at the pull-off for 4 minutes. She had then gotten back in the car and had driven down the mountain to the farmhouse. She had walked through the farmhouse, the rooms unchanged, Leonard's furniture still in place, the kitchen with the wood stove he had cooked on for 70 years, the porch with its eastern view across the water to the cabin-covered bank. She had stood on the porch and had looked at the eastern bank directly, not from the ridge elevation now, but from the lake's surface level, the cabins visible as a continuous development, the docks extending into the water at regular intervals, the structures clearly built within the shoreline zone. She had counted them from the porch, 26. She had noted the time in the small notebook she carried in her coat pocket, 3:47 p.m. She had walked back through the farmhouse, gotten in the car, and driven back to Asheville. She had not called anyone from the lake. She had not photographed the cabins. She had not knocked on any door or spoken to any resident. She had driven 3 hours back to Asheville in the November dark and had gone directly to the filing cabinet in her home office where the probate documents were stored. The 1938 deed was in the probate file, 8 pages, the original deed, recording information on the cover sheet, the Alderman family names on page 1, the legal description on pages 2 through 5, and the water rights reservation on page 6. She had read page 6. She had read it twice, the first time quickly, confirming what she already believed she would find, and the second time, slowly, following each clause with the particular attention of a land use attorney who had spent 30 years reading conveyance language and understood the difference between language that was ornamental and language that was operative. The reservation clause was operative. It had always been operative. It was 8 lines of plain conveyance language that said exactly what it said. Exclusive right to authorize or deny any commercial use, residential use, or infrastructure installation on or in the lake's water column, bed, or shoreline within 50 feet of the ordinary high water mark, running with the land in perpetuity, binding on all successors and assigns. 26 cabins, 26 docks, an access road along the bank, all of it within the 50-foot shoreline zone, none of it authorized by the owner of the water rights. She had closed the probate file and had looked at the wall of her home office for a moment. The bookshelves, the property law volumes she had accumulated over 30 years of practice, the framed survey map of a land use project she had completed in 2008 that she kept on the wall because the survey was beautiful, and because it reminded her that land was specific, bounded, and described, and that the description was what mattered. She had picked up the phone and had called James Okafor. James had answered on the 3rd ring. It was 9:15 p.m. on a Saturday, but James was the kind of attorney who answered calls from former colleagues, regardless of the hour, because he had learned over 25 years of property rights work that the calls that came after business hours were usually the ones that mattered. Nora had said, "James, I inherited my father's lake property in North Carolina. I drove up today for the first time. There are 26 cabins built on the eastern bank, inside the shoreline corridor, without any authorization from the water rights holder." James had said, "Who is the water rights holder?" Nora had said, "I am. As of October 2021, by inheritance from my father Leonard Voss, who acquired the lake and the water rights reservation in 1938. James had been quiet for 2 seconds. He had said, "What does the reservation clause say?" She had read him page 6. He had been quiet for 4 seconds after she finished. He had then said, "Who built the cabins?" She had said, "I don't know yet. I counted 26 from the porch. They look recent, the past 2 or 3 years based on the construction quality visible from across the water. They're organized as a development. There's an access road connecting them along the bank." James had said, "I'll start the title search Monday. I need the parcel number for the Eastern Bank land and the recording information for the 1938 deed." She had said, "Parcel HR-001-0044 is my parcel, the 140 acres in the lake. The Eastern Bank is a separate parcel. I don't have its number yet. The 1938 deed is Book 14, page 212, Harlan Ridge County Register." James had said, "I'll pull both parcels Monday morning. Nora, before you do anything else, I want you to sit on this until I have the complete title chain. Don't contact the developer. Don't contact the HOA. Don't send any letters. Give me 2 weeks." She had said, "I know how to wait, James." He had said, "I know you do. That's why I'm not worried about the 2 weeks. I'm telling you anyway." She had said, "Book 14, page 212. He had said, "I'll read it Monday." She had ended the call and had sat in the home office chair, looking at the probate file on the desk. 8 pages. Page 6 with the reservation clause, the language her father had read before he signed his name at the register's office on a Thursday in October 1938, when the leaves were off the hardwoods and the lake had cost $1,400, and the Alderman family had wanted the conveyance to be unambiguous about what they were giving and what the buyer was getting. Leonard had known what he was getting. The deed had said what it said for 83 years. Nora was going to give it 2 weeks, and then she and James were going to let it say what it said to the people who should have read it before they broke ground. James had pulled the Harlan Ridge County Deed Index on Monday morning at 8 a.m., the county's online records system, the index searchable by parcel number, grantor name, grantee name, and recording book and page. He had started with Book 14, page 212, the recording reference Nora had given him Saturday night, because the 1938 deed was the foundation of everything that followed, and he needed to read it himself before he read anything else in the chain. The deed had loaded on his screen in a scanned image. 8 pages, the handwriting on the first page and the formal cursive of a county register's office clerk from 1938, the typewritten body text on the subsequent pages in the standard conveyance format of the period. He had read it from page 1 to page 8 without stopping, the way he read every deed in a title examination, sequentially, without skipping to the provisions he expected to find, because the provisions he did not expect to find were always the ones that mattered. Page 6 had confirmed what Nora had read to him on Saturday night. He had read the water rights reservation clause 3 times, once for comprehension, once for the specific legal effect of each phrase, and once to assess the clause's drafting quality, which determined how susceptible it was to an interpretive challenge. The Alderman family's attorney had been thorough. The clause covered surface rights, riparian rights, water column rights, and bed rights, all 4 categories, enumerated separately, leaving no gap for an argument that one category had been conveyed while another had been reserved. The 50-foot shoreline corridor was defined by reference to the ordinary high water mark, a defined legal standard, not a vague description, the ordinary high water mark being a surveyable boundary that could be located on the ground. The authorization right, the exclusive right to authorize or deny commercial use, residential use, and infrastructure installation, was stated affirmatively and in 3 categories, each one covering a different type of activity that might occur on the shoreline. The perpetuity and successor binding language was standard and unambiguous. The clause had been drafted by someone who understood what they were doing. There was no interpretive gap he could find in 3 readings. The reservation said what it said, and it said it clearly. He had written in his examination notes, 1938 Deed, Book 14, page 212, Water Rights Reservation Clause, page 6, operative, unambiguous, comprehensive, covers surface, riparian, water column, and bed rights to Voss Lake. Exclusive authorization right for commercial, residential, and infrastructure use within 50-foot shoreline corridor measured from ordinary high water mark. Runs with land in perpetuity, binding on successors and assigns. No interpretive gap identified. He had then moved to the Eastern Bank parcel. The Eastern Bank had required a separate parcel search. James had found it through the county's GIS mapping system, overlaying the parcel boundaries on the aerial photography until he identified the parcel that occupied the Eastern Bank and matched the development visible in the aerial images. The parcel was HR-001-0061, a 34-acre tract running along the eastern bank from the lake's northern curve to its southern shoal. The parcel's western boundary following the ordinary high water mark of the lake's eastern shore. He had pulled the deed history for HR-001-0061. The current owner of record was Lakeview Pines HOA LLC, the homeowners association entity that had taken title to the common areas and access infrastructure of the cabin development. The 26 individual cabin parcels had been separately platted and were held by individual owners, their deeds recorded in a series of instruments filed between March 2021 and August 2022, as Derek Caulfield's Caulfield Land Group LLC had completed the cabins and closed individual sales. James had traced the parcel back through the chain of title. Caulfield Land Group LLC had acquired HR-001-0061 in June 2019 from Paul Edward Voss. The grantee's deed recorded June 14, 2019. The purchase price stated as $485,000. The deed signed by Paul Voss as an individual grantor. James had noted Paul's name and had held it while he continued reading the chain backward. Paul Edward Voss had inherited HR-001-0061 in 2003 from his father Raymond Voss. Raymond having died intestate, the property passing through the Harlan Ridge County Probate Court to Paul as Raymond's sole heir. Raymond Voss had acquired the parcel in 1962 from Leonard Voss, the original family division. A deed recorded September 8, 1962, Leonard conveying the Eastern Bank parcel to his brother Raymond as part of a family property division that had separated the 140-acre Voss holding into the lake and farmhouse parcel on the Western Bank and the Eastern Bank parcel. The 1962 division deed had been the critical instrument. James had read it with the same sequential attention he applied to every deed. 4 pages, the conveyance from Leonard to Raymond of the Eastern Bank acreage. The legal description running from the northern property corner, south along the eastern shoreline, to the southern corner and east to the ridge. Standard family division language on pages 1 through 3. Page 4 had contained a single paragraph he had read twice before he moved on. This conveyance is made subject to all easements, restrictions, covenants, and reservations of record affecting the above described property, including, but not limited to, the water rights reservation recorded in Book 14, page 212, Harlan Ridge County Register of Deeds, which reservation is hereby incorporated by reference, and shall remain in full force and effect as a condition of this conveyance. Leonard had included the Book 14, page 212 reference explicitly in the 1962 division deed. He had not assumed Raymond would check the title. He had written it into the conveyance instrument itself. The water rights reservation incorporated by reference. The condition stated plainly, the reservation's force and effect preserved as a condition of the transfer. Raymond had received the Eastern Bank parcel subject to his brother's water rights reservation. Paul had inherited it subject to the same reservation. Paul had sold it to Derek Caulfield, subject to the same reservation. The Book 14, page 212 reference, had been in the chain of title at every step, in the 1962 division deed that had created the Eastern Bank parcel as a separate holding, in Raymond's estate instruments, and by implication, in every subsequent transfer, because a reservation incorporated by reference into a division deed ran with the land, regardless of whether subsequent deeds repeated the language. James had written, 1962 division deed, Leonard Voss to Raymond Voss. Page 4. Explicit Book 14, page 212 reference. Reservation incorporated by reference. Stated as full force and effect condition of conveyance. Chain of title carries reservation from 1938 through 1962 division, through Raymond's estate, through Paul Voss's ownership, to 2019 sale. Reservation present in chain at every step. He had then requested the 2019 title commitment. The title commitment had taken 3 days to obtain. James had submitted a public records request to the Harlan Ridge County Register's office for the instrument filings associated with the June 2019 Caulfield Land Group acquisition, and had separately contacted the title company that had issued the commitment, a regional firm called Mountain Title Associates, whose name appeared on the recorded deed. Mountain Title had produced the commitment file on Thursday, 34 pages, the standard Alta title commitment format. The commitment date of May 2019, the proposed insured listed as Caulfield Land Group, LLC. James had gone directly to Schedule B, the exceptions section, the portion of a title commitment that listed the recorded instruments, easements, restrictions, and other encumbrances that the title policy would not insure over. Schedule B was where Book 14, page 212, should have appeared as an exception, because a water rights reservation of the scope and character described in the 1938 deed was precisely the type of instrument that a title examiner was required to identify and list as an exception to coverage. Item 14 of Schedule B had read, reference to instrument recorded in Book 14, page 212, Harlan Ridge County Register of Deeds. Note, examiner review indicates this instrument is a historical water rights notation from 1938, of no current legal effect, no exception required. James had read the notation twice, no current legal effect. He had pulled up the 1938 deed on his screen and had read page 6 again, the reservation clause, the perpetuity language, the successor binding language. Said rights to run with the land in perpetuity and to be binding on all successors and assigns. He had then read Mountain Title's Schedule B notation again, no current legal effect. The title examiner at Mountain Title Associates had identified Book 14, page 212. They had pulled it, they had read it, or they had read enough of it to characterize it. They had then concluded, incorrectly, that a water rights reservation from 1938 that explicitly stated it ran with the land in perpetuity had no current legal effect. They had cleared the exception rather than listing it. They had told Derek Caulfield, through the title commitment, that the 1938 reservation was not an encumbrance he needed to worry about. Derek had proceeded on that assurance. He had broken ground on the first cabin foundation in August 2020, 14 months after the 2019 closing, the development timeline documented in the county's building permit records, which James had also requested. 26 building permits, issued between August 2020 and March 2022. 26 sets of foundation and framing inspections. 26 certificates of occupancy. Not one permit application had referenced Book 14, page 212. Not one inspection had noted the 50-foot shoreline reservation. The county building department had issued the permits based on the parcel's zoning and setback requirements. Setbacks measured from the property line, not from the ordinary high water mark. The 50-foot shoreline corridor was a private contractual reservation, not a zoning regulation, and the building department had no mechanism to catch it. James had mapped the cabin locations against the shoreline corridor on Friday, using the county's GIS system, the aerial photography showing each cabin's footprint, the ordinary high water mark shown in the county's survey data, the 50-foot corridor drawn as an overlay. He had done the mapping carefully, measuring each cabin's closest foundation point to the ordinary high water mark, noting the dock locations, noting the access road alignment. Every cabin was inside the corridor. The closest cabin foundation to the ordinary high water mark was 11 feet. The farthest was 43 feet. All 26 cabin foundations, all 26 dock structures, and the access road running along the bank were within the 50-foot zone that the 1938 deed reserved to Leonard Voss and his successors. Every structure on the eastern bank required Nora's authorization. None had been authorized. James had written the final line of his examination notes on Friday afternoon. 26 cabin foundations, 26 dock structures, 1 access road, all within 50-foot shoreline corridor, all constructed without authorization from water rights holder. Water rights holder, Nora Voss. Successor to Leonard Voss. 1938 deed, Book 14, page 212. Title commitment error. Mountain Title Associates Schedule B, Item 14. Mischaracterized reservation as historical notation of no current legal effect. Error caused Derek Caulfield to proceed without obtaining authorization or easement. Developer built on protected shoreline. HOA and 26 individual cabin owners purchased encumbered property without knowledge of encumbrance. He had called Nora. She had answered on the second ring. It was Friday evening, the end of the 2 weeks James had asked for, and Nora had been waiting with the particular patience of a land use attorney who knew that title examinations took the time they took, and that calling to ask about progress was a way of adding time rather than reducing it. James had said, "Nora, I have the complete title chain. I want to walk you through it." She had said, "Go ahead." He had said, "I'll start with the 1938 deed because it's the foundation. I've read page 6 3 times. The reservation clause is operative, unambiguous, and comprehensive. It covers all 4 water rights categories: surface, riparian, water column, and bed. The 50-foot corridor is defined by the ordinary high water mark, which is a surveyable standard. The authorization right covers commercial use, residential use, and infrastructure installation, which are the 3 categories that matter here. The perpetuity and successor binding language is standard and clean. There is no interpretive gap in the clause. It says what it says. She had said, Leonard's attorney was thorough. James had said, the Alderman family's attorney was thorough. Leonard was the buyer. He benefited from the thoroughness. She had said, the chain. He had said, Leonard divided the property in 1962, conveyed the eastern bank to his brother Raymond. The 1962 division deed incorporated the Book 14, page 212 reference explicitly on page 4. Leonard wrote it into the division deed as a stated condition of the conveyance. Raymond took the eastern bank subject to the water rights reservation. Raymond died intestate. Paul inherited it. Paul held it until 2019. The reservation ran with the land at every step. She had said, Paul's sale to Caulfield. He had said, June 2019, $485,000. The title commitment was issued by Mountain Title Associates. I have the Schedule B. Item 14 identified Book 14, page 212. They found it. They pulled it. They read it. Their examiner characterized it as a historical water rights notation from 1938 of no current legal effect and cleared the exception. The commitment told Caulfield the reservation was not an encumbrance. Nora had been quiet for 3 seconds. James had said, "The examiner's characterization was wrong. A water rights reservation that explicitly states it runs with the land in perpetuity and is binding on all successors and assigns has current legal effect regardless of its age. The 1938 date does not diminish the reservation's force. The perpetuity language is the reservation's entire operative point. It was written in 1938 to bind owners in 1962 and 2019 and 2021 and every year thereafter." Mountain Title cleared an exception they should have listed. She had said, "The cabins." He had said, 26. "I mapped every foundation against the ordinary high water mark using the county's survey data. The closest is 11 feet from the mark. The farthest is 43. All 26 cabin foundations, all 26 dock structures, and the access road are inside the 50-foot corridor. Every structure on that eastern bank required your authorization. None was authorized." Caulfield broke ground in August 2020 on a protected shoreline he believed was clear based on a title commitment that misread a reservation his own acquisition deed referenced explicitly. She had said, "The HOA." He had said, "Lakeview Pines HOA holds the common areas. 26 individual owners hold the cabin parcels. They purchased from Caulfield between March 2021 and August 2022. Their deeds conveyed whatever Caulfield had to convey, which was a parcel encumbered by a water rights reservation they were not told about because the title commitment had cleared it." She had said, "They bought cabins on my shoreline without knowing the shoreline wasn't Caulfield's to sell." James had said, "That is precisely what happened. Caulfield didn't know either. He relied on Mountain Title's clearance. But his reliance on a flawed title commitment does not extinguish a reservation that has been in the county's deed records since 1938, and that was explicitly referenced in the division deed that created the parcel he purchased." She had said, "What is the HOA's refinancing schedule?" James had said, "I pulled the county's deed records for any financing instruments. The HOA recorded a construction loan in 2020, a $3.8 million instrument from a regional bank. I found a notice of intent to refinance in the county's UCC filings from August 2022. Based on the timeline, I'd expect the refinancing closing in the next 60 to 90 days. She had said, "I want to be in the room when that closing happens." James had been quiet for 2 seconds. He had said, "That is achievable if we move correctly. The refinancing requires a title commitment from the lender's title company. The lender's title examiner will find Book 14, page 212 in the chain. It is referenced explicitly in the 1962 division deed, which is in the chain of title for every individual cabin parcel and for the HOA's common area parcel. A competent examiner will flag it. If they flag it and call us, we confirm the reservation's current legal effect, and the lender pulls the commitment until the title issue is resolved." She had said, "And if the examiner makes the same mistake Mountain Title made?" James had said, "Then we attend the closing and place the 1938 deed on the table ourselves. Either way, the closing is the moment. The reservation is in the record. The lender needs clean title to close. We are the reason the title is not clean." She had said, "Find out when the closing is scheduled." He had said, "I'll monitor the county's recording activity in the UCC filings. The lender's title commitment will show up in the instruments filed against the HOA parcel. When it appears, we'll have the closing date." She had said, "James, the 26 families." He had been quiet for a moment. He had said, "They bought in good faith. Caulfield sold them cabins on a protected shoreline without disclosing an encumbrance that was in the deed records since 1938. The families are not the wrongdoers. The wrongdoing is in the title chain. Mountain Title's clearance error, and Caulfield's development of a shoreline he didn't have the rights to develop." She had said, "The family still bought my shoreline." James had said, "They did. The reservation doesn't disappear because the buyers were innocent, but the remedy doesn't have to be cabin removal. It can be a recorded easement that authorizes what's already there, with compensation for the unauthorized use period. That is the most likely settlement outcome. The closing day is the moment we establish what the deed says. The negotiation comes after. She had said, Book 14, page 212. James had said, I'll have a complete written analysis to you by Monday, and I'll start monitoring the refinancing timeline. She had said, I'll be ready when you find the date. She had ended the call and had sat in the home office with the probate file in front of her. 8 pages, page 6 face up on the desk, the water rights reservation clause in the typewritten body text that Leonard Voss had read before he signed his name at the register's office in October 1938. He had read it. He had known what it said. He had written it into the 1962 division deed, so Raymond would know what it said. Raymond had passed it to Paul. Paul had sold it to a developer who had relied on a title examiner who had looked at the clause and concluded, incorrectly, that 83 years of age had diminished language that explicitly said it ran forever. It had not. The deed said what it said. It had been saying it since October 1938, and it was going to say it in a title company conference room whenever James found the closing date. Nora was going to be there when it did. James had found the closing date on a Wednesday in late September, the lender's title commitment appearing in the Harlan Ridge County Deed Index as a recorded instrument against the HOA's common area parcel, the commitment issued by an Asheville-based firm called Blue Ridge Title Group. The closing date stated in the commitment's cover page as Tuesday, October 18, 2022, at 9 a.m. at Blue Ridge Title's county seat office. He had called Nora the same afternoon. He had said, October 18th, 9 a.m., Blue Ridge Title Group, the county seat office on Courthouse Square. She had said, Who is the lender's title examiner? He had said, A staff examiner at Blue Ridge named Thomas Aldred. I pulled the commitment. Schedule B, Item 11 lists Book 14, page 212. Aldred found it. He did not clear it the way Mountain Title did. He listed it as an open exception and flagged it for resolution before closing. She had said, He called you. James had said, Yesterday morning. He had identified the reservation and identified me as the water rights holder's attorney through the county's recent instrument filings. I had filed a notice of interest against the parcel last month, which is why he called rather than calling Mountain Title. He wanted to know the reservation's current legal status. She had said, What did you tell him? James had said, I told him the reservation is operative, unambiguous, runs with the land in perpetuity, and has not been modified or extinguished by any subsequent instrument. I told him the water rights holder is Nora Voss, successor to Leonard Voss, and that no authorization for the construction of residential structures or dock infrastructure within the 50-foot corridor has been granted by the water rights holder. I told him the encumbrance is real and the title is not clean. She had said, What did he say? James had said, He said he would need to report the exception to the lender, and that the lender would need to make a determination about whether to proceed, postpone, or require the exception to be resolved before closing. He said the closing is still scheduled for October 18th, but the lender may pull the commitment if the title issue is not resolved before then. She had said, I want to be in that room on October 18th. James had said, I've already called Blue Ridge and advised them that the water rights holder and her attorney intend to appear at the closing as interested parties. They are not required to admit us, but as the holders of a recorded encumbrance that is an open exception on the title commitment, we have a recognized interest in the proceeding. They said they would consult with the lender. She had said, And the lender? James had said, The lender called me this morning after Aldred's report. A senior loan officer named Patricia Webb. She wanted to understand the encumbrance. I gave her the same analysis I gave Aldred. She said the bank's position is that the closing will proceed as scheduled, and that the title issue will be addressed in the room. She wants all parties present, the HOA, the developer, and the water rights holder. Nora had said, Derek Caulfield will be there. James had said, He is listed on the closing documents as a party. The refinancing includes a release of certain construction liens Caulfield filed against the HOA's common area parcel in a dispute over common infrastructure costs. He has a financial interest in the closing. He will be there. She had said, Good. James had said, Nora, I want to walk through what we are doing in that room. We are not there to stop the closing permanently. We are there to ensure the lender understands what Book 14, page 212 says before the commitment is finalized. The closing will stop when the title exception is addressed. The lender will not close over an open water rights reservation of this scope. The moment the room understands what the reservation says, the closing is on hold, and the negotiation begins. She had said, "I understand the mechanism. I've been in title company conference rooms before." He had said, "I know. I'm saying it for the record." She had said, "I'll drive up the night before." She had arrived in the county seat on the Monday evening, checked into the Mountain Inn 2 blocks from Courthouse Square, had dinner alone, and had gone to bed at 10 with the probate file on the nightstand. She had not needed to review it. She had read page 6 enough times that the reservation clause was available to her in the specific way that operative legal language became available after sufficient readings. Not memorized word for word, but understood in its structure, its categories, its legal effect. The way she had understood the land use statutes she had applied for 30 years without needing to look them up. She had woken at 5:30 and had dressed and had walked to the courthouse square in the October dark. The mountain town quiet at that hour, the leaves at peak color on the ridges visible in the pre-dawn sky, the title company's office dark on the square's eastern side. She had walked the square once and had gone back to the inn for coffee and had met James in the lobby at 8:15. He had been carrying 2 file folders, the complete title chain in one, the 1938 deed, and his written analysis in the other. He had said, "Aldred confirmed last night that the lender is proceeding with the closing as planned. Patricia Webb's position is that she wants the title issue addressed in the room with all parties present before any documents are signed." Nora had said, "Who else is confirmed?" James had said, "Sylvia Grant, HOA president, and 2 other board members. The HOA's general counsel, a local attorney named Daniel Marsh, Derek Caulfield with his attorney Carol Breen, the Blue Ridge closing officer, a woman named Susan Holt. Thomas Aldred will be there as the title examiner. Patricia Webb by phone from the bank's Asheville office." Nora had said, 9 people in a phone call. James had said, "plus us." She had picked up her coffee cup. She had said, "Let's go." They had arrived at Blue Ridge Title Group at 8:52, the office on the square's eastern side, the conference room visible through the glass-fronted lobby, the table already set with document packages at each seat. Susan Holt had met them at the reception desk and had shown them to 2 seats on the conference room's northern side. Nora and James, across the table from where the HOA's party would sit, the arrangement placing them in direct sightline of everyone at the table. The HOA party had arrived at 8:57. Sylvia Grant first, a woman in her early 50s in a dark blazer, 2 board members behind her. Daniel Marsh, the HOA attorney, carrying a briefcase and looking at Nora and James with the specific attention of an attorney who has been told the Water Rights Holders Council will be present and is assessing the situation. Sylvia had looked at Nora without recognition and had taken her seat. Derek Caulfield had arrived at 9:02 with Carol Breen. Derek, a tall man in his late 40s, a developer's confidence in his posture, the kind of physical ease that came from years of breaking ground and selling units and moving to the next project. He had looked at Nora and James and had said something quietly to Carol, who had nodded. Thomas Aldred and Susan Holt had taken seats at the table's head. Patricia Webb had called in at 9:05, her voice on the conference room speaker, a clear, precise voice, the tone of a senior loan officer who had managed complicated closings before and preferred to manage them efficiently. Susan Holt had opened the session. She had said, "Good morning. We are here for the Lakeview Pines HOA refinancing closing on the common area infrastructure for parcel HR-001-0061 and associated parcels. Before we proceed to the document review, I want to address an open title exception that has been flagged in the commitment. Thomas, do you want to introduce the item?" Thomas Aldred had said, "Yes. Schedule B, Item 11 of the commitment, references an instrument recorded in Book 14, page 212, Harlan Ridge County Register of Deeds. The instrument is a deed from 1938, conveying Voss Lake and surrounding acreage to Leonard Voss. The deed contains a water rights reservation clause that I have reviewed and have listed as an open exception because I believe it has current legal effect that bears on the title to the subject parcel." He had looked at Nora. He had said, "Ms. Voss is the current holder of the water rights described in the reservation. Her attorney, James Okafor, has confirmed the reservation's current legal status. I asked them both to be present so the lender and all parties have a direct opportunity to understand the encumbrance before we proceed. Patricia Webb's voice from the speaker had said, "Thank you, Thomas. Ms. Voss, or Mr. Okafor, would you like to address the reservation?" Nora had said, "I would. Before I do, I'd like to place a document on the table." She had removed the 1938 deed from James's file folder, the 8 pages, the recording information on the cover sheet, the certified copy stamp from the Harlan Ridge County Register's office. She had set it in the center of the table. She had said, "This is the deed recorded in October 1938, Book 14, page 212, Harlan Ridge County Register of Deeds. My father, Leonard Voss, is the grantee. I am his successor in title by inheritance. Before we proceed with the closing, I want the lender and all parties to understand what page 6 of this deed says." She had turned the deed to page 6 and had slid it to the center of the table. She had said, "I'll read the relevant language. The grantor hereby conveys all surface rights, riparian rights, water column rights, and bed rights to Voss Lake, together with the exclusive right to authorize or deny any commercial use, residential use, or infrastructure installation on or in the lake's water column, bed, or shoreline within 50 feet of the ordinary high water mark, said rights to run with the land in perpetuity, and to be binding on all successors and assigns." The conference room had been quiet. Patricia Webb's voice from the speaker had said, "Mr. Okafor, is there any recorded instrument modifying or extinguishing this reservation subsequent to 1938? James had said, "None. The reservation has been in the chain of title for every instrument affecting parcel HR-001-0061 since the 1962 division deed that created the parcel. The 1962 deed incorporated the Book 14, page 212 reference explicitly on its face. The reservation runs with the land from 1938 to the present without modification." Sylvia Grant had reached across the table and had picked up page 6. She had read it. She had set it down. She had looked at Nora. She had said, "What does this mean for our cabins?" Nora had said, "It means every cabin on your eastern bank was built inside my water rights corridor without my authorization. Every dock, the access road, all of it is within the 50-foot shoreline zone that my father's deed reserved in 1938 and that I hold today." Derek Caulfield had taken the page from where Sylvia had set it. He had read it. His expression had not changed in the visible way that expressions change when a person is surprised. It had changed in the internal way, the specific stillness of a person who has just understood something that alters the value of everything he has built and sold in the previous 2 years. He had looked at Carol Breen. Carol had said, "When was this reservation first identified in the title chain?" James had said, "The reservation was identified by Mountain Title Associates in their 2019 title commitment for Mr. Caulfield's acquisition of the parcel. It appeared as Schedule B, Item 14. The examiner characterized it as a historical notation of no current legal effect and cleared the exception. That characterization was incorrect." Carol had said nothing for 4 seconds. Patricia Webb's voice had said, "I need to consult with our title counsel before this closing proceeds. Susan, I'm going to ask that we hold the document execution pending a 24-hour review. The open exception needs to be fully analyzed before the bank can commit to closing over it or determine what resolution it requires." Susan Holt had said, "Understood. I'll note the hold in the file." The room had been quiet. Sylvia Grant had been looking at page 6 of the 1938 deed still sitting in the center of the table. The typewritten reservation clause, the language that said what it said in the same plain terms it had said it, since the Alderman family's attorney typed it on a machine in 1938, and the Harlan Ridge County Register's clerk had filed it in Book 14 at page 212, and the index had recorded it, and the record had held it for 84 years, waiting for someone to sit in a title company conference room on a Tuesday morning in October and read it aloud. She had said, quietly, to no one in particular, or perhaps to the room, "What does this mean for our cabins?" No one at the table had answered immediately. Outside the conference room window, the October light was full on the courthouse square, the leaves at peak color on the courthouse elms, the mountain ridges visible on 3 sides of the town. The sky, the particular blue of a western North Carolina October morning. Nora had looked at the deed on the table. Page 6, the reservation clause. Her father's name on page 1 is the grantee, her name in the county's deed index as his successor, the water rights running from the 1938 recording date to this morning, in an unbroken chain that no mischaracterization in a title commitment had diminished, and no developer's groundbreaking in 2020 had extinguished. She had said nothing further. The deed had said everything that needed to be said. Patricia Webb had called Susan Holt at Blue Ridge Title at 8 a.m. the following morning. The 24-hour review completed, the bank's title counsel having spent the previous afternoon and evening reading the 1938 deed, the 1962 division deed, Mountain Title's 2019 commitment, and James Okafor's written analysis that Thomas Aldred had forwarded to the bank's legal department the same evening as the closing. Patricia had said, "We are withdrawing the commitment pending title resolution. The water rights reservation is a material encumbrance that was not disclosed in the 2019 title commitment and has not been resolved. The bank cannot close on a refinancing of infrastructure that is built inside a recorded water rights corridor without authorization from the corridor's holder. The commitment is withdrawn until the encumbrance is cleared by a recorded instrument satisfactory to the bank's title counsel." Susan had noted the withdrawal in the file and had called Daniel Marsh at the HOA and Carol Breen at Caulfield Land Group before 9 a.m. The refinancing was on hold. Derek Caulfield had driven back to Asheville the afternoon of the closing. The 4-hour drive, Carol Breen in the passenger seat, the two of them covering the legal situation in the first hour and then driving in silence for the remaining 3. He had been in the development business for 22 years and had encountered title problems before, boundary disputes, undisclosed easements, survey errors, but he had not encountered a title problem of this dimension. A reservation clause from 1938 that covered the entire shoreline corridor of a lake development he had already built and sold. He had sold 26 cabins. He had collected the purchase prices. He had distributed the proceeds and had moved the capital into 2 new projects. The money from Lakeview Pines was not sitting in an account he could write a check from. It was in the ground on 2 other sites in western North Carolina. He had called Carol from the car on the drive back and had said, "What is our exposure?" Carol had said, "Significant." The reservation covers residential use within the 50-foot corridor. Every cabin is in the corridor. Every buyer purchased a cabin that encroaches on a recorded water rights reservation that was not disclosed in their title commitment, because Mountain Title cleared an exception they should have listed. Your exposure runs in 3 directions: to Nora Voss for unauthorized use of the protected shoreline, to the 26 cabin buyers for selling them encumbered property without disclosure, and potentially to Mountain Title for the clearance error. Derek had said, "Mountain Title, we have title insurance." Carol had said, "You have a title insurance policy issued by Mountain Title based on the 2019 commitment. The policy insures against title defects that were not disclosed in the commitment. The reservation was identified in the commitment. It was item 14. Mountain Title found it, reviewed it, and cleared it. The policy's coverage question is whether clearing a known exception constitutes a covered defect, or whether identifying the instrument and making an incorrect legal determination about it falls outside the policy's coverage. That is a coverage dispute we are going to have with Mountain Title's insurer." Derek had said, "And in the meantime." Carol had said, "In the meantime, you have a refinancing that is stopped because the lender's title examiner correctly identified an encumbrance that your title examiner incorrectly cleared. The HOA's 26 cabin owners are going to learn about this within 48 hours if they haven't already. And Nora Voss's attorney is going to send a demand letter." Derek had said, "How long before the demand letter?" Carol had said, "I'd expect it within 2 weeks. They waited for the closing to make the reveal. They've been sitting on this since November 2021. They're not moving impulsively." Derek had said, "What does she want?" Carol had said, "Based on what Okafor said in the closing room, she wants the unauthorized use acknowledged, compensation for the period since construction began, and a recorded easement authorizing what's already built. She's not asking for the cabins to be demolished. She's a land use attorney. She understands that the practical remedy is an easement, not removal. But the compensation figure for 2 years of unauthorized use of a protected shoreline on a 1,400-acre mountain lake is going to be significant. Derek had said, "Call Mountain Title's claims department Monday morning." Carol had said, "I will." "Derek, I want you to understand that the coverage dispute with Mountain Title may take months to resolve. In the meantime, Nora Voss's claim is against the current encroachment, which is your development on her protected shoreline. Mountain Title's coverage question is a separate track from resolving her claim." Derek had said nothing for a moment. He had looked at the mountain road passing outside the window, the western North Carolina ridges in the October afternoon, the same ridges that had made the Lakeview Pines development marketable, the Lakeviews that had justified the cabin prices. He had built the development on a shoreline that was not his to build on the assurance of a title examiner who had found the relevant instrument and read it incorrectly. He had said, "Set up a call with Mountain Title Monday, and get me the name of the best property rights litigator in Asheville who doesn't already represent Nora Voss." Sylvia Grant had driven back to the lake from the county seat closing with the 2 board members in her car. An hour's drive, the October Mountain Road, the conversation in the car covering the closing room revelation in the fragmented way that conversations cover information that has not yet been fully processed. She had said, somewhere on the mountain road, a deed from 1938. One of the board members, a man named Robert Yee, who owned Cabin 7, had said, "It was in the title chain the whole time." Sylvia had said, "Mountain Title cleared it." Robert had said, "Mountain Title said it had no current legal effect. It clearly has current legal effect." The other board member, Karen Chu from Cabin 19, had said, "What happens to our cabins?" Sylvia had said, "I don't know yet. I'm calling a property attorney tomorrow." She had not called a property attorney the next day. She had spent Wednesday on the HOA's community portal, the online platform the 26 cabin owners used for community communications, writing and revising a message to the cabin owners that described the closing day event in terms that conveyed the seriousness of the situation without conveying its full legal dimensions, because she did not yet know the full legal dimensions, and she did not want to alarm 26 households on the basis of a 1-page clause she had read in a title company conference room. The message had gone out Wednesday evening. At yesterday's refinancing closing, a title issue was identified relating to a recorded instrument from 1938 that may affect the HOA's common area. The closing has been postponed pending resolution of the title matter. The board has retained legal counsel to review the situation and will provide a full update within 72 hours. Please direct questions to the board president. 22 replies had arrived before midnight. The most direct had been from Paul Finch at Cabin 3. "Sylvia, what does may affect mean? Does this affect our individual cabin titles or just the common area?" Sylvia had not replied to Paul Finch that evening. Ross Tanner had been a real estate litigator in Asheville for 16 years, not a title examiner, a litigator. The distinction being that Ross was the attorney you called when the title work had already gone wrong, and you needed someone who knew how to fight the resulting dispute in court. Sylvia had called him Thursday morning on Daniel Marsh's recommendation. Daniel having concluded after 20 minutes of his own research Wednesday evening that the situation was outside his transactional practice and required a litigator. Ross had said, "Send me the 1938 deed, the 1962 division deed, Mountain Title's 2019 commitment, and James Okafor's analysis if you have it." Sylvia had said, "I have the 1938 deed. Okafor left a certified copy on the table. I don't have the others yet." Ross had said, "I'll pull them from the county's records. Give me until Monday." He had called Sylvia on Monday afternoon. The call had lasted 22 minutes, and Sylvia had not interrupted it. Ross had said, "I've read the complete title chain. I want to give you the analysis in sequence so the conclusion makes sense when I get to it." He had started with the 1938 deed. He had said, "The reservation clause on page 6 is operative and unambiguous. It covers 4 water rights categories: surface, riparian, water column, and bed. It reserves the exclusive authorization right for commercial use, residential use, and infrastructure installation within the 50-foot shoreline corridor. It runs with the land in perpetuity and binds all successors and assigns. There is no ambiguity in the drafting, and there is no subsequent instrument in the chain that modifies or extinguishes it. The clause says what it says, and it has said it since 1938. Sylvia had said, "Mountain Title said it had no current legal effect." Ross had said, "Mountain Title's examiner was wrong. A reservation that explicitly states it runs in perpetuity and binds all successors does not lose its legal effect because of its age. The 1938 date is irrelevant to the reservation's operative force. The perpetuity language is the point. The reservation was written in 1938 precisely to bind owners in 1962 and 2019 and 2022. It does. He had moved to the 1962 division deed. He had said, "This instrument created the Eastern Bank parcel as a separate holding when Leonard Voss conveyed it to his brother Raymond." Page 4 of the division deed incorporates the Book 14, page 212 reference explicitly, states that the conveyance is subject to the water rights reservation, names the recording book and page, and says the reservation remains in full force and effect as a condition of the conveyance. Leonard Voss wrote the reservation reference into the instrument that created the parcel you own. Every owner since Raymond, including Paul Voss, who sold to Caulfield, held the parcel subject to an encumbrance that was named in the deed that gave them title. Sylvia had said, "Paul Voss sold to Caulfield." Ross had said, "In 2019, Paul's attorney should have found the 1962 reference and disclosed the reservation. Mountain Title should have listed it as an open exception rather than clearing it. Two separate points in the transaction chain where the reservation should have been surfaced and was not, one by error, one by incorrect legal analysis. Neither error extinguishes the reservation." He had then addressed the cabin locations. He had said, "I pulled the county's survey data and mapped the cabin foundations against the ordinary high water mark. All 26 cabin foundations are within the 50-foot corridor. The closest is 11 feet from the mark. The farthest is 43. All 26 dock structures are within the corridor. The access road is within the corridor. Every structure on the eastern bank requires Nora Voss's authorization under the 1938 reservation. None was authorized." Sylvia had said, "What is the way out?" Ross had been quiet for 4 seconds. He had said, "I've looked for a way out, and I want to be honest with you about what I've found." The navigability argument, the theory that the lake is a public water body subject to public trust doctrine, doesn't apply here. Voss Lake is a private natural lake with no navigable water connection. The public trust doctrine requires navigability in fact, and this lake doesn't meet the standard. The adverse possession argument, the theory that Caulfield's construction and the subsequent HOA ownership have extinguished the reservation through adverse use, requires the statutory period, and the construction started in 2020, 2 years ago. The statutory period in North Carolina for adverse possession is 20 years. We are 18 years short. The waiver argument, that Nora Voss's failure to object during construction constituted a waiver of the reservation, fails because she inherited the property in 2021 and learned of the construction on her first visit. She did not stand by while construction proceeded with knowledge. She inherited into a situation that was already substantially complete and moved methodically. Sylvia had said, "Find another argument." Ross had said, "I've considered the equitable estoppel theory, the argument that the HOA and the cabin buyers relied on Caulfield's representations and should be protected from the reservation's effect. The estoppel theory is the most sympathetic argument, but it has a fundamental problem. Equitable estoppel requires reliance on a representation by the party to be estopped, and Nora Voss made no representation to anyone. She was not in the chain of the sale. The cabin buyers relied on Caulfield's representations and Mountain Title's clearance, not on anything Nora Voss said or did. You cannot estop someone who made no representation. Sylvia had said, "So there is no way out." Ross had said, "The reservation is valid, it runs with the land, and every structure on the eastern bank is within the protected corridor." The legal position is that the HOA and the 26 cabin owners hold property that encroaches on a recorded water rights reservation that was not disclosed in their individual title commitments. The practical resolution is a negotiated easement. Nora Voss authorizes the existing structures through a recorded instrument in exchange for compensation for the unauthorized use period and an ongoing easement fee. That is the most likely settlement outcome, and based on what I know of Okafor's approach, probably the outcome Nora Voss has been prepared to negotiate since November 2021. Sylvia had said, "She's been sitting on this for a year." Ross had said, She inherited in October 2021. She drove to the lake, saw the cabins, went home, and read the deed. She retained Okafor, who spent 2 weeks on the title chain. They've known the complete picture since November 2021, and they waited for the refinance and closing to surface the issue. That is 11 months of patient preparation before they placed the deed on the table. Sylvia had said, she chose the closing day specifically. Ross had said, the refinancing created the moment. A lender requiring clean title, all parties present, the bank's own title examiner flagging the exception. The closing was the most efficient venue for establishing what the deed says, in front of everyone who needed to understand it simultaneously. Sylvia had said, that is cold. Ross had said, it is methodical. There is a difference. The HOA community portal had reached 180 messages by Thursday, the 26 cabin owners processing the closing room event in real time. The board's 72-hour update window having expired without the full disclosure Sylvia had promised. Paul Finch at Cabin 3 had posted the most direct question. My title company told me my title was clean. If there is a water rights reservation on this shoreline, why wasn't it in my title commitment? A cabin owner named Margaret Holt at Cabin 22, a retired contracts attorney who had read the 1938 deed page 6 language in Sylvia's Wednesday evening message and had recognized it immediately as operative reservation language, had posted, I pulled Book 14, page 212 from the county's online records this morning. The reservation is 8 lines on page 6 of an 8-page deed. It explicitly states it runs with the land in perpetuity. It was in the deed records since 1938. I would like to know how our title companies did not list this as an open exception. The answer to Margaret Holt's question was Mountain Title's 2019 clearance decision, which had cascaded through each individual cabin sale as the title commitment for each buyer had relied on the prior clearance. But Sylvia had not yet explained that to the community, because she was not sure how to explain it without directing the community's anger at Derek Caulfield, in a way that might complicate the board's legal strategy. She had not needed to direct the anger. It had found its own direction. A cabin owner named Thomas Park at Cabin 11 had posted Saturday morning. I called Derek Caulfield's office yesterday. He did not return my call. I called again this morning. His assistant told me he was unavailable. I paid $340,000 for this cabin. I would like to speak with the man who sold it to me. By Sunday evening, the portal thread had 260 messages. 12 cabin owners had called Derek Caulfield's office. None had received a call back. Derek's phone had been going to voicemail because Carol Breen had advised him not to speak directly with the cabin owners until the mountain title coverage question was resolved, and the legal strategy between Derek and the HOA was coordinated. It was sound legal advice. It was also, from the cabin owner's perspective, the behavior of a developer who had sold them something and was now unavailable to discuss it. The portal thread's tone had shifted over the weekend from concern to anger, the specific anger of people who had paid significant money for mountain lake cabins and had arrived at the understanding that the lake shoreline their cabins sat on might not have been Caulfield's to sell. Margaret Holt at Cabin 22 had posted Sunday evening. The 1938 deed has been in the Harlan Ridge County Register's records for 84 years. It is available to anyone who submits a records request or accesses the county's online deed index. Our title companies did not list it as an open exception. The developer sold us cabins on a protected shoreline. I think the board needs to stop managing this situation and start explaining it. Sylvia had read the post at 9 p.m. Sunday from the porch of Cabin 14, the October lake visible in the dark, the dock extending into the water below the dock sitting inside a 50-foot corridor that a woman in Asheville held the exclusive authorization rights to. She had called Ross. She had said, the community is going to force a disclosure meeting by midweek if I don't call one myself. Ross had said, call one yourself. Monday evening. Tell them what the deed says and what the legal position is. The community has already found the deed online. Margaret Holt's post demonstrates that. You are not managing information at this point. You are managing the response to information that is already in the community. Sylvia had said, and Derek Caulfield. Ross had said, Derek's exposure to the cabin owners is separate from the HOA's negotiations with Nora Voss. His attorney will advise him on how and when to communicate with the buyers. Your obligation is to your 26-member community. Sylvia had said, "What do I tell them?" Ross had said, "Tell them what the deed says. Tell them the reservation is valid, and the legal position is that every structure on the eastern bank is within the protected corridor. Tell them the board is in active negotiations, and the expected resolution is a recorded easement authorizing the existing structures. Tell them the developer's title company made an error in 2019 that cascaded through every subsequent transaction. And tell them the board is committed to resolving the situation in a way that protects their cabin ownership." Sylvia had said, "Can I promise them their cabins are safe?" Ross had been quiet for 3 seconds. He had said, "You can tell them that Nora Voss's attorney has not sought injunctive relief or cabin removal. The demand letter, when it comes, will ask for acknowledgement, compensation, and a recorded easement, not demolition. The practical resolution preserves the cabins, but I cannot promise outcomes in a negotiation that hasn't started yet." She had said, "I'll call the meeting for Monday." She had looked at the lake from the porch for a long moment, the dark water, the dock, the October night around the cabin. She had bought Cabin 14 in July 2021 for $385,000. The view, the dock, the mountain lake, the things she had told herself she had earned after 30 years in marketing. She had paid for a lakefront cabin with full water access rights on the assurance of a title commitment that had cleared an exception without reading it correctly. She had said, to no one and to the lake, a deed from 1938. The lake had not answered. It ran as it ran. The eastern bank, the 26 cabins, the 26 docks, the access road, all of it inside a 50-foot corridor that a woman in Asheville had inherited from her father and had driven to see on a Saturday in November and had read about on page 6 of an 8-page deed, and had waited 11 months to surface in a title company conference room on a Tuesday morning in October. The deed had said what it said. It was going to keep saying it until a negotiated instrument told the county register's office to record something different. Carol Breen had submitted the title insurance claim to Mountain Title Associates Claims Department on Monday morning, a formal written claim under policy number MT-2019-4471-CL. The policy issued to Caulfield Land Group, LLC, in connection with the June 2019 acquisition of parcel HR-001-0061. The claim had been accompanied by a 12-page letter of representation describing the encumbrance, the closing day event, the lender's withdrawal of the refinancing commitment, and the legal analysis establishing the 1938 reservation's current operative effect. The claims department had acknowledged receipt Tuesday and had assigned the claim to a senior coverage analyst named Warren Cole. Warren had called Carol on Friday. He had said, "Ms. Breen, I've reviewed the claim file and I want to discuss the coverage question with you directly before we issue a formal position letter." Carol had said, "Go ahead." Warren had said, "The policy covers title defects that were not disclosed in the title commitment. The standard coverage provision insures the insured against loss or damage sustained by reason of defects in, or liens or encumbrances on the title that are not accepted from coverage in Schedule B. The operative question for coverage is whether the water rights reservation is accepted from coverage in Schedule B." Carol had said, "Schedule B, Item 14 identified the Book 14, page 212 instrument and characterized it as a historical notation of no current legal effect. The examiner cleared the exception. The reservation was not listed as an open exception. It is not accepted from coverage." Warren had said, "That is one reading of the commitment. Our reading is different. The policy insures against defects not disclosed in the commitment. The commitment disclosed the instrument. Item 14 identifies Book 14, page 212 by recording reference, describes it as a water rights instrument from 1938, and states the examiner's legal determination that it has no current legal effect. The instrument was disclosed. The examiner's legal characterization of the disclosed instrument may have been incorrect, but the instrument itself was not hidden from the insured." Caulfield Land Group received a commitment that identified the 1938 deed and stated the examiner's conclusion about it. Carol had said, "The examiner's conclusion was wrong. The reservation has current legal effect. The commitment told our client a known encumbrance was not an encumbrance. That is, a title defect that the commitment failed to disclose correctly." Warren had said, "The distinction we are drawing is between a defect not disclosed and a defect disclosed but incorrectly analyzed. The policy's coverage is triggered by non-disclosure. The argument we are evaluating is that the commitment disclosed the instrument, identified it by recording reference, and made a legal determination about it. If the legal determination was incorrect, the question is whether that constitutes a covered title defect under the policy language, or whether it constitutes a professional error in the examination that falls under the examiner's professional liability rather than the title policy's coverage. Carol had been quiet for 4 seconds. Warren had said, "I want to be direct with you. Our preliminary position is that the coverage question is genuinely disputed. The instrument was identified in the commitment. A legal determination was made about it. Our examiner's determination was incorrect. Whether an incorrect legal determination about a disclosed instrument constitutes a covered title defect or a professional liability claim against the examiner is the question our coverage counsel is analyzing. We are not denying the claim. We are telling you the coverage dispute is real, and the resolution will take time." Carol had said, "How much time?" Warren had said, "Our coverage counsel needs 60 to 90 days to analyze the policy language, the commitment, and the relevant North Carolina case law on the distinction between non-disclosure and mischaracterization. We will issue a formal coverage position letter within that window." Carol had ended the call and had called Derek. She had said, "Derek, the title insurer is disputing coverage. They are not denying. They are saying the coverage question is disputed, and they need 60 to 90 days for their coverage counsel's analysis. The argument is that the instrument was disclosed in the commitment, and the incorrect legal characterization of a disclosed instrument may fall under professional liability rather than title policy coverage." Derek had said, "Professional liability, Mountain Title's examiner." Carol had said, "The examiner who cleared item 14. If the coverage dispute goes the insurer's way, your remedy is against the examiner under professional liability, rather than against the title policy. The examiner's professional liability carrier is a separate track from the title policy coverage." Derek had said, "How long does the professional liability track take?" Carol had said, "Longer. Professional liability claims require establishing the standard of care, demonstrating deviation from that standard, and proving damages caused by the deviation. It is a more complex proceeding than a title policy claim, and it is a separate proceeding from Nora Voss's claim against the encroachment." Derek had said, "Which means what for the timeline?" Carol had said, "It means the title insurance track and the professional liability track are both pending, both disputed, and both measured in months. In the meantime, Nora Voss's demand letter has not yet arrived, but it is coming. When it arrives, her claim is against the current encroachment, the HOA's cabins on her protected shoreline. The settlement of her claim cannot wait for the coverage dispute to resolve. You may need to contribute to the settlement from your own resources and recover from the insurer and the examiner's carrier afterward." Derek had said, "Contribute how much?" Carol had said, "I don't know yet. The demand letter will tell us what Nora Voss's figure is. Based on the duration of the unauthorized use, construction from August 2020, 2 years and 2 months to the closing date, and the character of the encroachment, 26 residential structures and dock installations on a protected shoreline of a 1,400-acre private mountain lake, the compensation figure is going to be substantial. I would not expect it to be under 7 figures." Derek had looked out the window of his Asheville office, the city below him, the mountains visible on the western horizon, the same mountain range that contained Harlan Ridge and Voss Lake, and 26 cabins he had built on a protected shoreline he had believed was clear. He had said, "Get me the demand letter as soon as it arrives." James had sent the demand letter to Derek Caulfield, the Lakeview Pines HOA, and Mountain Title Associates simultaneously. 3 separate letters, each one addressing the recipient's specific position in the chain of liability. All 3 sent by certified mail and email on a Thursday morning, 3 weeks after the closing day. The letter to Nora Voss's primary counterparty, addressed to both Caulfield Land Group and the Lakeview Pines HOA jointly, as the parties whose conduct and ownership most directly implicated the 1938 reservation, was 17 pages. James had structured it the same way he structured every demand letter in a property rights matter. The ownership foundation first, then the chain of title establishing the encumbrance, then the specific violations, then the compensation calculation, then the demands. The ownership section had been 3 pages. The 1938 deed's conveyance language, the reservation clause quoted in full, the chain of title from Leonard Voss through the Harlan Ridge County probate to Nora, the current ownership confirmed by the recorded transfer instrument. James had written, Ms. Voss holds the exclusive right to authorize or deny residential use and infrastructure installation within the 50-foot shoreline corridor of Voss Lake. This right has been continuously held by the Voss family since 1938 and is now held by Ms. Voss as Leonard Voss's successor in title. It is not subject to any adverse claim, public easement, or navigable water exception. It is a private property right recorded in Harlan Ridge County's deed records and operative under North Carolina law. The chain of title section had addressed the 1962 division deed, Paul Voss's 2019 sale, and Mountain Title's clearance error, not to establish the HOA's or Caulfield's culpability, because the demand letter was not a liability brief, but to establish that the reservation had been in the chain of title at every step, and that no instrument in the chain had modified or extinguished it. The violation section had been 4 pages, the 26 cabin locations mapped against the 50-foot corridor, each cabin's nearest foundation point to the ordinary high water mark stated in feet, the dock structures described, the access road alignment noted. James had written, every residential structure, dock installation, and infrastructure element on the eastern bank of Voss Lake has been constructed and operated within the protected shoreline corridor without authorization from the water rights holder. The first construction activity within the corridor occurred in August 2020, based on the county's building permit records. The unauthorized use has continued without interruption through the date of this letter. The compensation calculation had been the most complex section, 4 pages, the methodology described in sufficient detail that the figure could not be challenged without first challenging the inputs. James had approached the compensation calculation from 2 directions and had presented both figures before identifying the demand figure. The first approach had been a market rate license fee analysis, the fair market rate for a commercial license to use a private lake's protected shoreline for a 26-unit residential development, determined by reference to 3 comparable private lake shoreline license transactions in western North Carolina between 2015 and 2021. The comparable transactions had produced license fee rates ranging from 8% to 14% of the development's total sale revenue. Caulfield's 26 cabin sales had generated aggregate revenue of $8.7 million. The individual sale prices documented in the recorded deeds, ranging from $285,000 for the smallest cabin to $425,000 for the largest, with a median price of $335,000. Applied to the $8.7 million aggregate at the midpoint rate of 11%, the market rate license fee was $957,000. The second approach had been an unjust enrichment analysis. The benefit Caulfield had received from developing and selling the protected shoreline without paying for the authorization. The benefit was the premium attributable to the lakefront location, the difference between the cabin sale prices and the estimated values of equivalent cabins without direct lake access. James had used a comparable sales analysis from a certified appraiser who had estimated the lake access premium at 35% of the total sale price for each cabin. Applied to the $8.7 million aggregate, the lake access premium was $3.045 million. James had written, the 2 approaches produce a range of $957,000 to $3,045,000 for the compensation attributable to the unauthorized use of the protected shoreline. Ms. Voss's demand is based on the market rate license fee approach as the more conservative figure, adjusted upward by 20% to reflect the absence of any negotiation prior to construction. The standard market rate figure assumes a negotiated license, and the failure to negotiate an authorization before proceeding with development warrants an adjustment above the standard rate. The demand figure, $1,148,400. The 4 numbered demands had been stated in the letter's final section. 1. Acknowledge, in a recorded instrument, Ms. Voss's fee-simple ownership of the water rights reservation described in Book 14, page 212, Harlan Ridge County Register of Deeds, and the reservation's current operative legal effect as a condition running with the land and binding on all successors. 2. Pay to Ms. Voss the sum of $1,148,400, representing compensation for unauthorized residential use and infrastructure installation within the protected shoreline corridor from August 2020 through the date of settlement. 3. Negotiate in good faith a perpetual recorded water access easement authorizing the continued existence and operation of the 26 cabin structures, dock installations, and access road within the 50-foot corridor, to include an annual easement fee reflecting the fair market value of the lake access rights conveyed, indexed to the HOA's annual assessment revenue. 4. Reimburse Ms. Voss's attorney's fees and costs in connection with this matter. The final paragraph had been James at his most direct. If the recipients do not respond to this demand within 30 days, Ms. Voss will file suit in Harlan Ridge County Superior Court, asserting claims for private nuisance, trespass to property, unjust enrichment, and a declaratory judgment confirming the reservation's operative legal effect and requiring the removal of all unauthorized structures from the protected corridor. Ms. Voss's preferred resolution is a negotiated easement that authorizes the existing structures and compensates her for the unauthorized use period. Her alternative is a court proceeding in which she will seek, among other relief, an order requiring the removal of all 26 cabin structures, 26 dock installations, and the access road from the 50-foot corridor at the defendant's expense. James had included the removal language deliberately, not because Nora intended to demolish 26 cabins, but because the legal right to seek removal existed, and its inclusion in the demand letter ensured that every party reading it understood what the alternative to negotiation looked like. 26 families, 26 cabins, removal at the defendant's expense. The figure attached to that outcome was not a compensation payment. It was a reconstruction cost, measured in millions. Carol Breen had received the letter Thursday afternoon and had called Derek at 4 p.m. She had said, "The demand letter is here, 17 pages, 4 demands. The compensation figure is $1,148,400 for the unauthorized use period. The forward demand is a perpetual recorded easement with an annual fee indexed to the HOA's assessment revenue. And there is a removal paragraph." Derek had said, "removal." Carol had said, "She has preserved the right to seek court-ordered removal of all structures from the corridor." It is stated as the alternative to negotiation. She is not leading with removal. The letter's framing is that a negotiated easement is the preferred outcome. But the removal right is in the letter, and every party who reads it understands what it means. Derek had said, "The HOA's 26 families." Carol had said, "Yes. If this goes to litigation, and she prevails on the removal claim, the defendants bear the cost of removing 26 cabins and 26 docks from a mountain lake shoreline. That cost is not calculable in advance, but it is substantial. The removal paragraph is the leverage that brings everyone to a negotiating table." Derek had been quiet for a moment. He had said, "Forward the letter to the Mountain Title Claims Department." Carol had said, "Already done." He had said, "What is Warren Cole's reaction going to be to the removal paragraph?" Carol had said, "I expect it will accelerate their coverage analysis timeline. A potential court order for structural removal significantly increases the insurer's exposure if coverage is ultimately found. The removal paragraph changes the coverage dispute's financial dimensions." Derek had said, "Good. Schedule a call with the HOA's attorney. We need a coordinated response to the demand. The HOA and I are separate parties, but we are both on the same side of this negotiation." Carol had said, "I'll call Ross Tanner tomorrow." Derek had said, "Carol, the $1.1 million figure, is that negotiable?" Carol had said, "Everything in a demand letter is a negotiating position until it is a settlement agreement. The figure is James Okafor's anchor. It is well documented and defensible. The question is not whether it is negotiable, but what range it will negotiate to, and how much of the final figure comes from you versus the HOA versus Mountain Title's contribution." Derek had looked at the mountain horizon through his office window, the same ridges, the same October light. He had built 26 cabins on a protected shoreline, based on a title commitment that had found the relevant instrument and misread it. The coverage dispute was pending. The professional liability track was pending. The demand letter was on the table. He had said, "Set up the call." The demand letter had gone out Thursday. By the following Monday, it had been read by Derek Caulfield, Carol Breen, Ross Tanner, Sylvia Grant, Daniel Marsh, Warren Cole at Mountain Title's Claims Department, Patricia Webb at the Lending Bank, and Margaret Holt at Cabin 22, who had obtained a copy through the HOA's portal when Sylvia had shared it with the board, and Margaret had forwarded it to the community thread with a post that said, "The demand letter is attached. I think everyone should read it, particularly page 14. Page 14 was the removal paragraph. The community thread had reached 340 posts by Tuesday morning. Paul Finch at Cabin 3 had posted, "I paid $340,000 for this cabin. I want to know what Derek Caulfield knew and when he knew it." Margaret Holt had replied, "He knew what his title commitment told him. His title commitment told him a reservation that runs in perpetuity had no current legal effect. His title commitment was wrong. The 1938 deed was in the county's records the whole time." Book 14, page 212. The deed had been saying what it said since October 1938. It was still saying it. Everyone was reading it now. Ross had called James the Monday after the demand letter arrived, 8 days inside the 30-day response window, early enough to signal that the HOA was not going to spend the window on a counter-argument it did not have. He had said, "James, Ross Tanner, the HOA wants to negotiate. We accept the framework, recorded acknowledgement, compensation, perpetual easement. We have counterpositions on the figures." James had said, "Nora's terms are in the letter. Tell me the counterpositions." Ross had said, "The compensation figure." The HOA's position is that the appropriate number should account for the HOA's status as a good faith purchaser. The cabin owners bought in reliance on Caulfield's representations and Mountain Title's clearance. They are not the wrongdoers. James had said, "The reservation runs with the land and binds all successors regardless of good faith. North Carolina property law does not have a good faith purchaser exception to a recorded encumbrance. The compensation figure reflects the market rate value of what the HOA has occupied without paying for, not a penalty for wrongdoing." Ross had said, "The HOA accepts the market rate approach. The dispute is the 20% upward adjustment for the absence of prior negotiation." James had said, "Nora will reduce it to 10%, bringing the figure to $1,053,000. That is the floor." Ross had said, "The annual easement fee. The HOA's counter is a fixed annual fee of $18,000, CPI adjusted every 5 years. James had said, "A fixed fee decouples the easement's value from the lake's appreciation." Nora's position is 7% of the HOA's annual gross assessment revenue, with a floor of $20,000 per year. The floor protects against the HOA reducing assessments to reduce the fee obligation. Ross had said, "I'll take 7% with the floor to the board." The first session had ended in 90 minutes, 2 of the 4 terms in working agreement, the figures in negotiating range. Derek's track had run parallel. Warren Cole at Mountain Title's Claims Department had called Carol Breen on day 58 of the coverage analysis window with the determination. He had said, "We are extending coverage. Our conclusion is that identifying an instrument and making an incorrect legal determination about it constitutes a disclosure failure for coverage purposes." The insured received a commitment that effectively told him the instrument was not an encumbrance when it was. "We are covering the loss up to the policy cap, $485,000, the 2019 acquisition price." Carol had said, "The demand figure is $1,053,000. Warren had said, "The policy covers $485,000. The balance is Derek's exposure." Carol had reported it to Derek. He had absorbed the number and had said, "What is my share?" She had said, $568,000 toward the lump sum. Plus, the annual easement fee obligation runs with the HOA's land. That transfers to future buyers and is not your ongoing cost. Your direct contribution is the $568,000. Derek had said, "And the examiner's professional liability." Carol had said, "A separate claim, a separate timeline. The $568,000 is your contribution to the settlement. Recovery from the examiner's carrier comes after." Derek had said, "Close the settlement." The final session had resolved the remaining figures. The compensation at $1,053,000, the annual easement fee at 7% of gross assessment revenue with a $20,000 floor, James's fees of $95,000 paid by Caulfield Land Group as the party whose title chain error had generated the proceeding. The recorded acknowledgement had been drafted by James, a two-page instrument confirming the 1938 reservation's operative legal effect, recorded against both the HOA's common area parcel and each of the 26 individual cabin parcels, and correcting Mountain Title's 2019 mischaracterization in a public document that would appear in every future title search on every Lakeview Pines property. The perpetual water access easement had authorized the existing 26 cabin structures, 26 dock installations, and the access road within the 50-foot corridor. The structures as of the settlement date, no expansion authorized without separate written approval from the water rights holder. The closing had been on a Friday in December. The instruments executed, the escrow funded, the $1,053,000 cleared before 10 a.m., the recording completed at the Harlan Ridge County Register's office by noon. James had called Nora at 12:20. He had said, "All instruments recorded. The acknowledgement is against all 27 parcels, the HOA's common area, and each of the 26 cabin parcels. The easement is recorded. The compensation cleared escrow this morning. The deed records show the reservation correctly for the first time since Caulfield broke ground in August 2020. She had said, cross-referenced in the index. He had said, Book 14, page 212 is now cross-referenced to the acknowledgement instrument, the easement instrument, and every individual cabin parcel deed. Anyone who searches any Lakeview Pines parcel going forward will find the reservation and the easement in the first results." She had said, "As it should have been from the beginning." He had said, "Yes, as it should have been from the beginning." She had said, "James, Leonard wrote that clause in 1938 for exactly this reason." He had been quiet for a moment. He had said, "I know. He just needed someone to read it." She had said, "I'll be at the lake tomorrow." She had set the phone down and had looked at the probate file on her desk. 8 pages, page 6 face up, the reservation clause and the typewritten body text that had been operative since the Alderman family's attorney prepared it in the fall of 1938, and Leonard Voss had signed his name, and the county register had assigned it Book 14, page 212, and filed it in the record where it had waited, correctly, through 2 family generations, and 1 development project, and 1 title commitment mischaracterization, and 11 months of patient preparation, and 1 closing room, and 3 negotiation sessions, and a December Friday recording. The deed said what it had always said. The records showed it correctly now. She would be at the lake in the morning. She had driven up from Asheville on Saturday morning. The 3-hour drive, the mountain road, the switchbacks on the upper section of Harlan Ridge. She had stopped at the pull-off at the ridge crest as she always had. The lake was there below her, 1,400 acres in the December morning, the hardwoods bare on the surrounding ridges, the surface flat and gray in the winter light. The eastern bank was visible from the pull-off, the way it had been visible on the November morning 14 months ago, when she had stood here and counted 26 cabins on a shoreline she had not yet fully understood was hers. The cabins were still there, the same structures, the same docks extending into the water, the same access road connecting them along the bank. Nothing on the eastern bank had changed visibly between that November morning and this December one. Everything in the county deed records had changed. She had stood at the pull-off for 4 minutes and had then driven down the mountain to the farmhouse. She had walked the eastern bank in the morning, not from the farmhouse side, which would have required a boat crossing, but from the access road that connected the eastern bank development to the county road on the ridge's lower slope. She had parked where the access road met the county road and had walked south along the bank, the gravel access road underfoot, the cabins on her left, the lake on her right, the December cold around her, and the water visible between the dock structures. The cabins were quiet at this hour. A Saturday morning in December, most of the owner's weekend residents who arrived Friday evening and were not yet outdoors. A light on in cabin 14, Sylvia Grant's cabin, the curtains drawn. Smoke from the chimney of cabin 3. the docks extending into the water at regular intervals, the lake surface flat between them. She walked the length of the eastern bank. 26 cabins, 26 docks, the access road from the northern curve to the southern shoal. She had walked it once, slowly, looking at the lake from the eastern side for the first time in her life. Her father had always accessed the lake from the western bank, the farmhouse side, the dock he had built in 1952, the aluminum fishing boat. The eastern bank had been open shoreline in her childhood, the deep channel below the hardwood roots, the bass holding in the summer heat. She had never stood on the eastern bank as a child. She was standing on it now as its water rights holder, the reservation clause on page 6 running beneath every structure she walked past, the ordinary high water mark at her right shoulder, the 50-foot corridor extending inland from the water's edge through every cabin foundation on the bank. The corridor was authorized now, recorded. The easement instrument in the county's deed index, cross-referenced to Book 14, page 212, the annual fee obligation running with the land. She had reached the southern end of the bank, where the access road curved back toward the ridge road. She had stood there looking north along the bank, the 26 cabins, the 26 docks, the lake surface running west to the farmhouse shore, where the old dock was visible as a thin line extending into the water. Her father had fished from that dock for 50 years. She had turned and walked back to the car. At the farmhouse, she had made coffee at Leonard's stove and had sat at his desk with the probate file. The file she had opened on the November evening 14 months ago, when she had driven back from the pull-off and gone directly to the filing cabinet. The file was thicker now, the original 8 pages at the bottom, the title chain analysis above it, James's written examination notes, the demand letter, the session summaries from the 3 negotiation meetings, the settlement instruments on top, the acknowledgement instrument, the perpetual water access easement, the compensation escrow confirmation, the recording receipts with the instrument numbers. She had read through the recording receipts, each instrument number noted, each parcel reference listed, the register's office timestamps showing the Friday noon recording. The acknowledgement was recorded against all 27 parcels. The easement was recorded against the HOA's common area parcel. Book 14, page 212, was cross-referenced in the county's deed index to both new instruments. She had opened the legal pad she kept in the file's back pocket, the same pad she had used for notes since November 2021, the first entry dated the evening she had read page 6 for the first time at this desk. She had read the notes from the beginning, the chain of title reconstruction, the questions she had written before calling James's callback 2 weeks later. Every cabin on that eastern bank is built inside your water rights corridor. The closing day session summary, the conference room, the deed on the table, Sylvia Grant reading page 6, Derek Caulfield going still, the negotiation session notes, the final figures, the December Friday recording. The last entry before today had been 1 line. Recording complete, all instruments filed, instruments cross-referenced to Book 14, page 212 in County Deed Index. She had uncapped the pen and written the final entry, 3 sentences. The deed says what it has always said. Page 6 runs with the land in perpetuity. The lake is recorded correctly. She had closed the file and set it back in the left drawer of Leonard's desk. She had taken her coffee to the porch, the western bank porch, the view east across the water to the eastern bank, where 26 cabins sat inside a 50-foot corridor that the December morning held in the same flat gray light it had held when she drove to the pull-off 14 months ago and counted the structures on a shoreline she had not yet fully understood. She understood it now. The 1938 deed understood it the same way it always had. 8 pages, page 6, the reservation clause in plain typewritten language that the Alderman family's attorney had prepared for exactly the reason it had ultimately been needed: to bind every owner, every developer, every title examiner, every successor and assign who would ever hold or touch or sell or build on the shoreline of Voss Lake, in perpetuity, until someone placed the deed on a conference room table and read the operative language aloud. Leonard had signed his name at the bottom in October 1938. She had placed it on the table in October 2022. The lake ran below the porch in the December morning, its surface flat and gray, the eastern bank quiet across the water, the farmhouse dock extending into the water at her right. Her father had built that dock. He had fished from it for 50 years. He had read the deed before he signed it, and he had known what page 6 said, and he had written it into the 1962 division deed, so Raymond would know, and Raymond had passed it to Paul, and Paul had sold it to a developer, whose title examiner had found it and misread it, and the lake had run as it ran through all of it. The 1938 recording, the 1962 division, the 2019 sale, the 2020 groundbreaking, the 2022 closing room, the December Friday recording. Its surface holding the light in the particular way that mountain lakes hold light in December, flat and gray and cold, and entirely indifferent to what the county's deed records said about who owned the water column below. The deed said what it said. The records showed it correctly. The lake was hers.